Good evening, good evening, good evening. I'm here on social media. I'm doing a live, and I'm going to wait for people to join me. I had a really interesting consult, and I want to talk about it. Good evening. I hope everyone has had a great day, relaxing at home. This is going to be a short live because I'm really hungry. I haven't eaten all day because I was so busy today. Whew, but I wanted to talk about this because, struck my spirit that this is something I need to discuss with you guys. So let's get started. And I'm going to introduce myself for those who do not know me or who are just joining my life for the first time. My name is Odunlami. I'm an immigration attorney from the Odunlami law firm in Cedar Knolls, New Jersey, and in Houston, Texas. We have 2 physical offices, but we represent clients in all 50 states and even abroad. If you have an immigration matter, we're here to assist you. If you have cases with regards to family-based, humanitarian, VAWA, U visa, T visa, deportation, habeas corpus, which is suing the government to get you out of detention, we do all of that. We're here to assist our fellow immigrants so that they can live here in the United States without fear of being deported, without fear of being separated by from their families. So let's get started. Hello, everyone. All right. So, hello, Edward. Nice to see you. All right. So it's going to be a short live, but if you have any questions, please post them. I'll try to get to them as soon as I can. But I really want to talk about this because this made me so sad, and I want to talk about it so that somebody out there, if this is you, if this is a situation you find yourself in, you really want to pay attention, or if you know somebody who is in this situation, you want to, send this video to them. Okay, don't forget to like and subscribe. We have a newsletter. If you go to my website, you can get we send out two newsletters every month, and it's packed full of information because I don't gatekeep. I give it to all of you. So I had a consultation with somebody, and this is what the situation is. And I'm going to change the details a bit so that just for privacy purposes. So this person did a consultation with me, and he had gotten a conditional green card at some point. Which meant that he had a US citizen who filed for him. They went for an interview. He got a 2-year green card, and he was supposed to remove the conditions on the green card. But there was so much abuse in this relationship, so much. There was he literally had to flee, because there was just a lot of bad things happening to him. And unfortunately for him, he sought advice from the wrong place. He went to the attorney who filed the marriage-based petition for him and basically asked what to do, and they gave him the wrong advice. So this attorney was not an immigration lawyer. It's one of those people who they'll file, the marriage petition because, it's an I-130. They file the forms. It's pretty, not too difficult. They file it, and maybe it wasn't an error where immigration actually was, doing things fairly, right? So he got the green card, and so when the relationship didn't work out, he went back to this person. And the truth of the matter is this person is already conflicted. They cannot advise you if they are the same person who filed your marriage green card. There's a conflict of interest, all right? And that's what this attorney should have told him. And secondly, because he told the attorney that he was being abused, and there was he had evidence of the abuse, but the attorney said to him, well, you don't have a police report, therefore you're not going to be able to remove the conditions on your green card. And I think the attorney said to him, well, he didn't have enough to file VAWA. He already had a green card. He didn't have to file VAWA. He just needed to file a waiver based on the abuse. But this attorney didn't tell him that, because this attorney was a real estate attorney, not an immigration attorney. So it's important that you understand that with immigration matters, you need to talk to an immigration attorney. There are people who do many different things, right? And some people dabble with a lot of things. They dabble a little family here, a little real estate, or a little estate, a little immigration. That does not mean they know immigration. And I'm going to tell you something. It's been said that the second most difficult area of law is immigration, second to tax law. And the reason immigration is so difficult is there's so many variances. This is the law, but this is the exception, and the exception has many exceptions. And if you came in this way, you went that. I mean, there are just so many ways that a case that looks straightforward is no longer straightforward. So guess what happened? So this guy was called to remove the conditions for an interview, but he was afraid, so he didn't go. And of course, when your I-751 is denied, and I'll talk a little bit about what the I-751 is for those that don't know it, but I just want to get through the story. So when he didn't show up for the interview, the case, of course, was denied. And when the case was denied for I-751s, it's always been the policy that when the I-751 is not approved, the person is referred to immigration court, which is deportation proceedings. And so the second mistake this man made was that since he didn't change his address with USCIS, or with EOI or whoever, so when he moved away from his wife's home and ran away for his life, he didn't change the address. And because he didn't change the address, he didn't get the notification to show up to court. And because he didn't get that notification to show up to court, he didn't show up to court, and he was ordered deported in absentia. So this was a case that could have been relatively uncomplicated, and if it was as easy as any immigration case can be, this was it, because he came in lawfully. He was married to a U.S. citizen. They were in a bona fide relationship. They had lots and lots and lots of proof of it. He got the temporary green card, and then that was where everything began to unravel. He went to the wrong attorney, who was a real estate attorney, gave him wrong advice, because what he should have done was to go to an attorney who understood I-751, and they would have told him, you can file a waiver based on abuse and continue on the process to get your green card on your own. You can file a waiver based on divorce and get your green card without your spouse. You can also even file, a waiver based on hardship. There were 3 ways this man could have gotten his 10-year green card. 3 ways. But because of fear, because he was afraid, right? And because he got the wrong advice from people, he's now been ordered deported. And all of you know what that means in this environment. When somebody's ordered deported in this environment, it means that they're very, if ICE comes and gets them, they're literally going to be put in detention and deported, because they've had their day in court, right? They don't go back to court to relitigate it, unless they file a motion to reopen. But what is the basis for the motion to reopen? Right now, he has none, right? Now, there are ways that he could get another green card while he's still here. There are ways. So it was a good thing he came to us, because we discussed all of these different ways that he could get another green card, because right now he doesn't have a green card. He's done. His green card has been terminated, revoked. He's now basically in a very dangerous situation, where if he had an encounter with ICE, he would be deported. And that would be so terrible, because he has children, young children here, right? So I want to go over this conditional removal for somebody who has a conditional removal green card. You need to understand that removal of conditions is not a suggestion. You must remove your conditions, all right? If you are married to a U.S. citizen and the marriage, and you got a green card within 2 years of the marriage, So at the time you got your green card, your marriage was 2 years or less, they will give you a temporary green card, which is a 2-year green card. Then you're supposed to remove the conditions 2 years, within 2 years of getting that green card. Typically 90 days before the green card expires, you're supposed to get the conditions removed. You must. It's mandatory. Because if you don't, they will put you in removal proceedings, right? And so if you are in a situation where you've been subject to abusive behavior, somebody's saying, why wouldn't this man allow him to stay due to hardship? Not necessarily. You should know this. Just because you have American children does not mean they will let you stay, because it has never meant that. But this administration will tell you to take your kids. You can take your American kids and be together as a family. That will not prevent him from being deported. All right. So that's my answer to you, M letter, right? So now I've had a lot of people who come for consultations, and they find out that they find out while we're doing the consultation that they've been ordered deported. They didn't know that. And then when you talk to them, you find out that the reason they didn't realize it was because either they didn't have a lawyer anymore, or they didn't change their address. That's typical, right? Or, one of those reasons. It's the second mistake this man made was, how is USCIS going to serve you with a notice to appear if they have your old address? It's your responsibility to change it, because if you don't get it because you didn't change the address, that's not an excuse. Now, if you change your address and for some reason they still use the wrong address, then that's on them. And you can make a motion to reopen based on the fact that you weren't properly served, right? All right. So we're seeing that a lot of I-751 cases are being denied because, a lot of, like I said, a lot of people got their green cards in the, maybe within 4 years, 5 years, and they didn't schedule it. They didn't have to have an interview. They were able to get approved on the papers that they submitted. That's not the case anymore. They're having interviews. And the I-751 interview is one of the most important interviews you must attend. In fact, every interview is really important. You need to talk to an attorney to determine, because there are times when a client doesn't attend an interview because they have another pathway, right? And we advise them, this is what you need to do so that USCIS is advised of what your intentions are. But you can't ignore interview notices, right? You can't ignore court appearances. You just can't. You can't even ignore ICE checkings, these things, or biometrics. Biometrics will get your case denied. If you don't show up for your biometrics, your case is going to be denied, because biometrics is a really important part of the immigration application process. You cannot not show up for your biometrics. Okay, these are things you need to know, because these are the little things that you might not have been advised that will take a relatively uncomplicated case into something that puts you in removal proceedings. So this guy, like I said, I listened to his story. He had a good abuse story, but even if he didn't want to go with the abuse, he could have just filed a divorce, gotten his divorce decree, put in a waiver for divorce, and all he had to show was that it was a good faith marriage, which he had copious evidence of. So now that he's been ordered deported, he's starting the process all over again, right? With some difficulty, because he doesn't have a work permit, right? And things have just gotten more complicated, especially for people who have been ordered deported. So if this is you or somebody you know, stop taking advice from your friends, cousins who filed their paper and they got their green card, or from the attorney who does real estate law, but sometimes does immigration. You really want to go to somebody who knows what they're doing. And you want to make sure that person has the experience in the area you're seeking. Like, we don't do EB-5s. So when people come to us with investment visa questions, we don't take it. We tell them we don't do EB-5s, right? And we work with clients in the areas that we do. That's what responsible attorneys do. All right. Yes, M letter, show your out of status friends that the American born kids may not make them untouchable. Now, if you have an American child who is over 21 and you as the parent came in and you were inspected when you came in, which means with a visa, that child could file for their parents, right? Now, if they have an immigration history where they've done something wrong, maybe some fraud, maybe came in with somebody else's identity, maybe committed a crime, the American-born child cannot help them because they're now inadmissible, and that child cannot be a qualifying relative for a waiver. But if they have been abused by the American child, that's also a pathway through VAWA M letter. So I'm telling you all this stuff so you can tell your friend, all right? But just having American-born kids does not make you untouchable, not one bit. Because if you're watching the news, you're seeing people being deported and their kids are here, all right? So I'm going to answer some questions. I'll start off with Aki Okoja says, do you think going for an ICE appointment is reasonable at this time? Hence, I enter IWI. Aki, I don't know your story. You need to talk to an attorney. If you entered IWI and you have an ICE appointment, you must be talking to an attorney. So I cannot address that. All right. I do not know your story and everything. We have clients who are going for ICE checkups, right? We know their story. We know what to tell them. Okay. Now, Helen says, how long does it take to get a K1 visa? Depends on what country you're from. You know, typically an hour, a year and a half, a year to 2 years, depending on what country you're from. But the K1 visa is actually a visa that's really helpful now in light of the pause for many countries, because the pause is for immigrant visas and the K1 is a non-immigrant visa. So in all those countries where there's a pause, you can still apply for a K1 visa. So that's a good question, Helen. All right. And let's see. So Dorcas says, you passed your citizenship last year. You were supposed to go for your court ceremony in November and it was canceled. How long do you think this cancel thing is going for? Dorcas Cobson, you have options. You can request a de novo review from federal court. The federal court they would have to explain why, you know, they're not proffering you for your court ceremony, and the judge can swear you in. You know, a lot of these cancellations make no sense. So Dorcas, give us a call. We may be able to help you and get your naturalization going. 973-993-1900, or you can call 713-600-1909, because that is actually happening a lot, and a lot of people don't realize that if all you had to do was your oath ceremony, there are ways that, you know, you may have options to continue the process and get your naturalization. Okay. So Livino says, my friend has a 5 years B1, B2 visa. He came to the US in 2023, spent only 1 week and went back. The visa is still valid. Please, can he come into the US now for 2 weeks? I mean, there's nothing that stops him, but guess what? CBP still has a right to deny him entry even with a valid visa. So they can, you know, do a secondary inspection, go through his things and think that, you know, he hasn't shown that enough ties to his country and they may turn him back. On the other hand, there's nothing that says he can't come in. So as long as he intends to go back and he can prove he intends to go back, he can give it a try because he still has a valid visa. Those visas haven't been revoked, you know. So, you know, he can try, but he really shouldn't stay longer than he intended to, because you want to have a history with USCIS, with immigration, of complying with the immigration rules. You say you're going to be here for 2 weeks, be here for 2 weeks and leave, okay? So M letter says your friends came in without inspection through Mexico. Then their kids cannot even help them if they came without inspection, unless they're filing VAWA because the American kids have been abusive to them. And Right now with the new VAWA policy, that is a really complicated, pathway, but it can be done. But if they came through Mexico without inspection, their children cannot file for them to adjust in the United States. Okay, they can adjust here and get a green card without having to leave. So Edward says, I have an approved I-140 based on NIW, but I have got an asylum pending. Will it be possible to adjust my status? It depends. Are you in legal status right now? And if you're not, did you file your asylum within the 6 months you came in here? Because then you would have no unlawful presence. So Edward, it really depends. Call an attorney. If you want us to assist you, feel free to call us at 973-993-1900. Political strategist says, when will all these pauses come to an end? I'm not sure, but hopefully soon. I don't know, quite frankly. Dorcas says, repeat the telephone number again slowly. Okay. It's 973-993-1900. I have to learn how to pin it. I don't know how to do so. But it's right on the, if you're on Facebook or YouTube, it's right on the banner, okay? You can call that number, or you can also call 713-600-1909. You can go to my website, www.odunlamilaw.com, and you can reach out to us through there. There's a contact sheet. All right. So God is Love says, hi, daughter filed for me, paperwork sent in 2 months ago. Biometrics is tomorrow, and I'm scared you filed for asylum before, and they told me to tell my daughter to file for you at the interview. All right. So God is Love. I don't see any reason why you can't go for your biometrics. As long as you don't have a criminal history, you're not in removal proceedings. I don't know what's going on with your case, but it shouldn't be a problem to do your biometrics. But the best thing to do is to talk to an attorney, because without knowing the details of your case, I can't really offer you meaningful advice. But a lot of people are going for biometrics, as long as, like I said, you don't have any criminal issues, you haven't been ordered deported, it should be okay. But that's based on just what you're telling me. But call an attorney. Don't play around with your immigration status. Don't take chances, okay? All right, Song Salami says, how long does a green card take to be approved after the submission of an RFE on I-693? It depends. Sometimes really quickly, sometimes it takes a while. It really depends on the field office. And right now, if you're from one of the countries that have a pause, they're not likely to make a decision right now. They're waiting for the pause to be lifted. So M Letter says, can being transported through Mexico via human trafficking network and then EWE qualify for a T visa? That's possible, because there's smuggling that turns into trafficking, which could qualify a person for a T visa. The trafficking must happen inside the United States borders. That's correct, M Letter, okay? All right, so that's all the questions on YouTube and Facebook. So let's see if we can get a couple of questions right here on Instagram. Let's see. So world government says you need my assistance. You can call us at 973-993-1900. You can check on my link tree, but make sure it's also you're talking to 973-993-1900, and the other number is 713-600-1909. Make sure you're talking to the right person. We sometimes have people pretending to be us and trying to scam people, okay? All right. How long does it take to approve VAWA? Right now, the processing time guideline says about 3.5 years, but it could take a little longer, okay? All right, let's see. All right. I know I'm really fast because I talk fast. Peter, all right, 973-993-1900. 973-993-1900 or 713-600-1909. Either number will reach us, okay? It's really the same number, just that one is Texas office, one is New Jersey office. It really doesn't matter. Either number, you can call from anywhere, you'll get us, okay? All right. I'm talking extra fast now because I'm really hungry. I need to go eat. All right, let's see if we can help out a few people from Instagram. I'm not seeing any questions on Instagram. So, okay, here it is. Tago says, it's advisable to file your tax as married, filing separate, even though you're still married. It's going to affect your I-751. Or you have to file what you are. If you're married and you're filing separately because you don't live together anymore, then file it. If you're together, then you should file it, married. When you file married filing separately, that USS is going to wonder why, or you're not living together. Now, if you file an I-751 based on a waiver because you're not together anymore, but maybe the divorce hasn't come through, go ahead and file married filing separate, but don't let a tax advisor tell you to file something that's not true because they want you to, because you want to make extra money. All right, like I say always, in the long run, it's cheaper to get a good attorney. Trust me on this. In the long run, it's cheaper to get a good attorney because sometimes the advice other professionals give you may work for them in that profession. For instance, your tax man may say, your accountant may tell you to file this, but it hurts your case. Or they think it's okay to say certain things, and it's not, because USCIS will consider it as fraud. So it's always a good investment to talk to a knowledgeable attorney about your case, whether or not you decide to use them, which I always recommend you use an attorney, especially in these times, okay? You don't want the headache of trying to figure out what the laws are, the policies changing and all that. But, in the end, you guys, you have to make your own decision, but you can't get legal advice from me on live because I'm giving general information. So Nze says, do you think someone who's a Canadian citizen can get an approval for VAWA, and how long does it take to get approval? Anybody can get approval for VAWA as long as you meet the criteria for VAWA. It doesn't matter where you're from, All right, yeah, VAWA is taking about 3 to 4 years, sometimes even more, But typically, when we check the processing guidelines, and we figure out how long it's supposed to take, and if it's the VAWA case hasn't been approved by then we have to determine what strategy we can go through with our client to assist them in bringing their case to a conclusion. Okay. So Prom Win said, what are the documents to apply for an adopted daughter from Nigeria? Listen, this adopted daughter thing is you have to, adoption is, for immigration purposes, is not as easy as you think it is. You must have adopted that child before she turns 16. All right. And adoptions from Nigeria are USCIS has a lot of problems with those adoptions. And you want to be careful with that. You want to talk to an attorney that does international adoptions with immigration, because we don't even do it, okay? So you really want to find an attorney who specializes in this, because there's a lot of craziness with the adoption paperwork in Nigeria that USCIS doesn't recognize, all right? All right, guys, it's 8 o'clock. I'm thankful for you guys for joining me, but I'm really hungry, so I'm going to run now. But I will be back on Thursday. I typically do my lives after work. So if you get a chance, please join me and let's chat, talk about what's going on. So, like for those who are looking to reach out to us, you can call us at 973-993-1900. Go to our website, www.odunlamilaw.com. All right, we're here to assist you to the best of our ability. Take care.